Hi everyone, I hope you're all doing well. So today we're going to look at striking off a defunct company, the company's register, and thereafter we shall look at amalgamations, mergers, and acquisitions. So let's begin with striking defunct companies off the company's register. What is a defunct company? A defunct refers to an organization or company that has zero assets and zero liabilities and fails to begin business within 1 year of its incorporation. So, in essence, defunct means non-operation. You're not operating. They're telling us that ever you've spent a year without operating ever since your incorporation, or you're a dormant company, you have no liabilities and no assets, right? Because if you did insolvency, you note that a company whose assets are heavier than its liabilities, it's solvent, whereas a company whose liabilities are heavier than its assets, it becomes insolvent or a good candidate of insolvent. But if a company who does not fall anywhere within there, you're not solvent, you're not insolvent, you've not begun work or business within 1 year of your incorporation, you become a defunct company or a dormant company. Let's look at circumstances under which such companies can be struck off the company's register. So it should be noted that the registrar of companies has authority to strike off defunct companies from the register of companies. Are we together? So one of the circumstances under which the registrar can strike off a company is where it fails to file annual returns of 5 years and above, right? Where you fail to file annual returns of 5 years and above. Annual returns are provided for from section 132 to section 134 of the, no, to section 136 of the Companies Act, right? So what are annual returns? So annual returns, simply put, you as a company, you need to update the registrar of companies about the indoor affairs of your company every year. At least every year you need to update them. Maybe if you have a secretary who left, you need to tell them that now in this year the secretary left. You need to you need to update them about how your company is a going concern, right? Let's read reading section 132 subsection 1 of the Companies Act provides that a company having a share capital shall at least once in every year make a return containing, with respect to registered office of the company, registers of members and debenture holders, shares and debenture indebtedness, past and present members and directors and secretaries. So you just need to inform or update the registrar of companies about the indoor affairs of your company, right? Because whether you're a company having a share capital or not, this is mandatory. And in case you fail to file annual returns for 5 consecutive years, that means that your company risks being struck off the register of companies. And it should be noted that regardless of the fact that the registrar has powers to strike your company off the register, they just don't wake up out of the blue and be like, now we feel like striking your reason being you failed to file annual returns for the past 5 consecutive years. No, they there is a process they go through. Perhaps they can even call you. Sometimes they call you to show cause why your company should not be struck off the company's register. And if you fail to show cause, that's when they can actually have it struck off. Because of recent, I think we've seen a number of companies being removed from the register of companies just because they have failed to file annual returns. So failure to file annual returns is provided for under section 134 subsection 5 and 6, right? Where subsection 4, where subsection 5, if after expiry of 5 years from date specified in subsection 1, the company has not filed any annual returns, the registrar shall require the company to file a statement of solvency and show cause why a company should not be struck off the register. So a statement of solvency simply shows that you're a going concern. Your company is a going concern. You're in good terms with your your creditors. You're not insolvent, right? So a statement of solvency simply shows that you're in terms. I mean, you're capable of paying your debts, right? And you have to show cause why your company should not be struck off. Okay, you give them reasons why you've not been filing annual returns. So that is one. Then two, cessation of business by a foreign company, right? Cessation of business by a foreign company. This is provided for under Section 259 of the Companies Act. 259, Section 259. Okay, 259. Subsection 1, they're telling us that where a foreign company ceases to have a place of business in Uganda, it shall immediately give notice in writing of the fact to the register of registration, and as from the date on which the notice is given, the obligation of the company to deliver any document to the register shall cease, and the registrar shall strike the name of the company of the register. So in case you're a foreign company but you've ceased to operate in Uganda, that means that you have no reason why you should still be on the register of companies. Then lastly, we shall look at section 265A. That's the amendment. It gives powers to the registrar to strike a defunct company of the register of companies in their own accord or by the request of that company. So you as a company, you can go and petition to have your company struck off the registrar. I mean the register of companies, right? Or at their own accord. So if they deem it fit to have you struck off, they can remove you, right? And they're now telling us that they should give you a notice of 30 days before striking you off, right? Then after, where there is no objection within 30 days, the company shall be struck off by the registrar, right? So that those are some of the circumstances under which a company can be, a defunct company can be struck off a company's register. So let's look at amalgamation and mergers or acquisitions. Amalgamation, mergers and acquisitions. Actually, amalgamations and mergers mean the same thing, right? Amalgamations and mergers mean the same thing. So let's look at what is an amalgamation. Amalgamation is merging two or more companies to form a new company or the already existing company through absorption. So this is where two or more companies come together to form one company, right? This is where two or more companies come together to form one company. So what are the reasons for amalgamation? One, for expansion, right? To get more branches around the country. That's expansion. For instance, in circumstances where let's say KFC wants to expand, it can amalgamate with Cafe Javas. Yes, it can amalgamate with Cafe Javas to expand its business in Uganda. Then secondly, one the reasons is to reduce competition. Yes, we have a lot of competition in Uganda, especially by these businesses. So if KFC and Cafe Javas deem it fit to seize that unnecessary competition, they can amalgamate. Then three, to acquire new products range or move into new markets. Yes. Then to obtain tax advantages. Yes, because you've been two companies paying different taxes, but now you're merging to form one company, right? So you will obtain a tax advantage. So before merging, you the amalgamating companies must conduct due diligence, which due diligence must also look at the financial status of both these companies, because the law tells us that both companies, in order to amalgamate, they should be solvent, and they should file a statement showing that they will remain solvent even after amalgamating. Are we together? So these two amalgamating companies, before amalgamating, they should conduct due diligence to ascertain the financial status of each other, right? So let's look at the process of amalgamation. The process of amalgamation starts from section 237 to 245 of the Companies Act, right? 237 to 245. Let's look at them. So section 237 tells us that subject to any restrictions in their respective incorporation documents, and to sections 238 to 241, two or more companies may amalgamate and continue as one company, which may be of the amalgamating companies or may be a new company. So section 237 gives companies powers to amalgamate. They tell you that two or more companies can actually amalgamate and either form a new company or form one of the amalgamating companies. So what do they mean by forming one of the amalgamating companies? Do you know that I've given you an example of KFC and Cafe Javas coming together to form one business. So they could come up with KFC and Cafe Javas can enter into a memorandum of understanding and be like, do you know what? We are going to amalgamate and form one company, which is we shall maintain KFC because it's selling in Uganda, right? It's very good at making profits in Uganda, right? So there it will have the two amalgamating companies, which is KFC and Cafe Javas, will have formed KFC, one of the amalgamating companies, right? But they can also be like, no, do you know what? KFC and Cafe Javas can come together and form maybe and form another company with a different name. That shall simply mean that the two amalgamating companies have formed a new company. Are we together? So let's look at section 238, authorization of amalgamation. Each company which proposes to amalgamate must authorize in the manner set out in section 241. 1. An amalgamation proposal, and 2. the proposed incorporation documents of the amalgamated company, which complies with section 240. So before companies amalgamate, or if any company proposes to amalgamate, one, they should have two documents. One document is the amalgamation proposal by both these companies, stating that they have actually done what? Consented to the amalgamation, and that the company, we shall see when you get to section 239. Let's begin with the amalgamation proposal. We've said that before any companies do an amalgamation, they should have at least two documents. One of the documents is the amalgamation proposal, and secondly, they should have the proposed incorporation documents. So we are going to look at them in details. Let's begin with the amalgamation proposal as provided for under section 237. It tells us, 239, it tells us that an amalgamation proposal for authorization under section 240 must set out the terms of the amalgamation, in particular, the manner in which shares of each amalgamating companies are to be converted into shares of the amalgamated company. So they're telling us that under the amalgamation proposal, these two companies must come to an agreement on how the shares shall be converted into that new company they intend to do what? To create, because these two distinct companies will have shares, independent shares, but they should show us how they should, how they will continue holding shares after amalgamating, right? Then secondly, if any shares of an amalgamating company are known to be converted into shares of the amalgamated company, the consideration what the holder of those shares are to receive instead of shares of the amalgamated company. So this simply tells us that, okay, you may enter into an amalgamation, right? But there are some shareholders who may not want to do what? Who may not want to be part of the new amalgamated company, right? So here they're telling us that you should show us how those shares which shall not be converted into shares of the amalgamated company shall be held. Are we together? Among others, right? Anyways, that is the that is the amalgamation proposal, and that's what it should entail. But you should also look at other things like place of business, where where the new company shall operate its business from. Where the amalgamated company shall operate. Then who shall be the leaders or the directors and shareholders of that amalgamated company, right? You should tell us all that under the amalgamation proposal as stipulated under section 239 of the Companies Act. So let's look at the incorporation document, because we've said that before amalgamation you should have at least the amalgamation proposal and the incorporation document. Those are the two documents we need. Then let's look at the incorporation document as stipulated under section 240. It tells us that the incorporation document for authorization under this section must be prescribed and must in particular state the name of the amalgamated company. Yes, so the incorporation document shall be the memorandum of association of the new company. Are we together? The proposed incorporation document shall be the memorandum of association of the new of the new amalgamated company. We shall state the name of the new of the amalgamated company, the share structure, the number of shares, the rights, privileges, and limitations, full names, postal and residential addresses of each director. Are we together? Registered office of the amalgamated company, the place where the amalgamated company records are to be kept, the amalgamated company's accounting reference date, among others. Are we together? So I've told you that we have two documents. One of the documents is amalgamation proposal, right? Then secondly, we have the incorporation document, the proposed incorporation document, which I've told you is the memorandum of association of the intended amalgamated company, the intended outcome of the two amalgamating companies. Okay, let's look at manner of authorizing amalgamations, right? Manner of authorizing amalgamation. It is provided for under section 241. Yes, section 241. They're telling us that the directors of each amalgamating companies must resolve in their opinion that 1. The amalgamation is in the best interest of the shareholders of the companies. Are we together? 2. That the amalgamated company will remain solvent immediately after the time at which the amalgamation is to become effective. So they should sign a certificate. They should sign a certificate, which certificate shows that it is to the directors' considered opinion that the amalgamation is the best interest of both the shareholders of both the amalgamating companies, right? Then secondly, that the amalgamated company will remain solvent even after amalgamation. I've told you solvency means that ability to pay your debts, where your assets are heavier than your liabilities, right? That's you are solvent. But insolvence is where your liabilities are heavier than your assets, to the extent that even if they sell all your assets, they cannot realize your debt, they cannot pay off your debt, right? That's insolvency. So here they're telling us that the directors should sign a certificate which shows that the amalgamation is in the best interest of the shareholders of both amalgamating companies, and secondly, that the amalgamated company shall remain solvent even after amalgamation becomes effective, right? Anyway, they're telling us that the directors of each amalgamating company must send to each shareholder of that company not less than 20 working days before the amalgamation is to take effect a copy of the amalgamation proposal, a copy of the proposed incorporation document, which incorporation document I told you is the memorandum of association of the new company or of the amalgamated company, and copies of the certificates given by each set of directors. So I've told you that this certificate should state that the amalgamation is in the best interest of both the shareholders of these companies, and secondly, that the amalgamated company shall remain solvent even after insolvency. Then let's see. After sending, who should authorize an amalgamation? The amalgamation, this is section 241, subsection 4. The amalgamation must be authorized by the shareholders of each amalgamating company by special resolution. So you may be given a question requiring you to talk about amalgamation and even draft the necessary document. The necessary document is a special resolution to amalgamate, right? A special resolution to amalgamate by shareholders of the by shareholders of these two amalgamating companies. So if these two if the shareholders of these two amalgamating companies have consented to the director's proposal of amalgamation, they're going to do what? They're going to pass a special resolution authorizing the amalgamation. Which resolution? I'm going to show you simply. I drafted one here. Let me just go through it briefly. The Republic of Uganda, in the matter of the Companies Act number 1 of 2012, and in the matter of, let's assume that our amalgamating companies are Cafe Javas and KFC. In the matter of Cafe Javas Company Limited, and in the matter of KFC Uganda Limited, and the matter of a resolution to amalgamate, special resolution, at the extraordinary general meeting of shareholders of both Cafe Javas and KFC Uganda Limited, held at Kampala Serena Conference Hall on the 14th day of April 2024, it was resolved as follows. 1. That the two amalgamating companies freely consent to amalgamate and form a new company called K, right? Called K. Then 2, that all be it as resolved by both the company's directors in relation to shareholding, location, and management of the amalgamated company, right? Then 3, that this resolution be filed with the registrar of companies and all stakeholders of both companies be duly notified. Dated at Kampala this 15th day of March 20 this 15th day of May year 2024. Then they sign off. So this is the resolution that will be required to draft in case you're told to draft the necessary document authorizing authorizing an amalgamation. I have told you that upon receiving a copy of an amalgamation proposal, a copy of the proposed incorporation document, and copies of certificates by the directors, the shareholders will resolve, right? Will pass a resolution to authorize the amalgamation. Are we together? Then let's look at registration of amalgamation. This is section 242. After an amalgamation has been authorized under section 241, the following documents must, within 10 working days after the resolution passed under the Act for the purpose of delivery, duly completed to the registrar in relation to the amalgamated company, its incorporation document, or if the amalgamated company is the same as one of the amalgamated companies, notice of change of incorporation. So here they're telling us that after the shareholders have authorized the amalgamation through a special resolution, you should file within 10 days, within 10 working days, file to the registrar of companies an incorporation document of an amalgamated company, right? Which incorporation document I've told you is the memorandum of association of the new company. That's if at all these two companies intend to form a new company, right? But in case these two companies do not intend to form a new company, but they intend to have one of them absorb the other, then they will just do what? They will just they'll just file a notice of change of incorporation document, which shall which notice shall lead to the cancellation of the other company which was absorbed, right? Yes. So yes, consents, certificates required. Then section 243 talks about certificates of amalgamation. The registrar must send to the company or a person from whom the documents required under section 242 were received if the amalgamated company is the same as one of the amalgamated company, a certificate of amalgamation, yes, together with an amended certificate of incorporation. So after you file to the registrar a notice of amalgamation or incorporation document, they'll give you a certificate of incorporation of a new company which you've formed, and a certificate of amalgamation, or a certificate of an amended certificate of incorporation. That's if at all one of the amalgamating after amalgamation, one of the amalgamating companies stayed and one of them died. One of them was absorbed by this one which stayed, right? Anyways, let's look at the effects of amalgamation. To section 243, subsection 3, I think. On the day shown in the certificate of amalgamation, the amalgamation becomes effective. B, the registrar must remove the amalgamating companies other than the amalgamated company from the registrar. From the register. I've talked about this. C, the amalgamated company succeeds all the property rights and privileges of each of the amalgamating companies. D, the amalgamated company succeeds all liabilities of each of the amalgamating companies. Are we together? The amalgamated company succeeds all the liabilities of each of the amalgamating companies. So the outcome of the amalgamation, the outcome company of the amalgamation succeeds all the liabilities of the amalgamating companies. So we can see there is a recent case that I came across. It was, I think it yes, I'm forgetting the party. The parties are Dr. Owaro, Dr. Vincent Oralo versus Toto Uganda Limited. It was pointed again that amalgamations do not defect ongoing proceedings against a company, right? Ongoing liabilities or legal proceedings against a company. Anyways, E, proceedings pending or against an amalgamating company may be continued by or against the amalgamated company. This is self-explanatory. So let's look at lastly, let's look at creditors' rights on amalgamation, where immediately after the time when an amalgamation becomes effective, an amalgamated company becomes solvent and an amalgamated company becomes insolvent, and creditor of any of the amalgamating companies may recover any loss he or she has suffered by reason of the amalgamation, if no certificate was given by the directors of that amalgamating company at the time the amalgamation was approved. So here they're telling us that immediately after the time of amalgamation, the amalgamated company becomes insolvent. The creditors of that company can actually recover from who? From this new company, if at all there was no certificate given by the directors of the amalgamated companies. But if at all there was a certificate given under section 240 by the directors, showing that actually the amalgamated company will remain solvent immediately after the time of incorporation, that shall mean that the creditors will recover their money from the director. The directors will be personally liable for the mislead, right? For misleading the creditors of the amalgamating companies, that actually the amalgamated company shall remain solvent after amalgamation, right? Then, if the certificate was given and if there were no reasonable grounds for the opinion that the amalgamated company would be solvency from the directors who signed the certificate. So this is explained under 2. And 1, they are telling you that if there is no certificate signed by the director showing that the amalgamation is in the best interest of the shareholders of the company, and that the amalgamated company will remain solvent immediately after the time at which the amalgamation is to become effective. This is under section 240. That means that the amalgamated company shall be liable for the debts of the creditors. But in case there was a certificate issued by the director showing that indeed the amalgamated company shall remain solvent after amalgamation. These directors shall become personally liable. What shall we do? Don't you think that we shall lift the corporate veil to have them? We shall lift the corporate veil and have them personally liable for the mislead because they issued a defective certificate. Are we together? Anyways, that's amalgamation for us. Thank you for listening.